interfere with these decisions according to these cases. Another issue that gives me great pause is Judge Kavanaugh's extreme view on guns. In reviewing his record and judicial opinions, it's clear his views go well beyond simply being pro-gun. During a lecture at Notre Dame Law School, Judge Kavanaugh himself said he'd be, quote, the first to acknowledge that most lower court judges have disagreed with his views on the Second Amendment. Specifically, in District of Columbia v. Heller, Judge Kavanaugh wrote in a dissenting opinion that unless guns were regulated, either at the time of the Constitution was written or traditionally throughout history, they cannot be regulated now, end quote. In his own words, gun laws are unconstitutional unless they are, quote, traditional or common in the United States, end quote. Judge Kavanaugh would have struck down D.C.'s assault weapons ban because they have not historically been banned. This logic means that as weapons become more advanced and more dangerous, they cannot be regulated at all. When I asked Judge Kavanaugh about his views that if a gun is in common use, it cannot be regulated, he replied this way, and I quote, "There are millions and millions and millions of semi-automatic rifles that are possessed."
This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service. This is the primary audio circuit for the Reuters live service.
He has said that sitting presidents cannot be indicted, cannot be prosecuted, should not be investigated, and should have the authority to fire a special counsel at will. In other words, the President of the United States is above and outside the law. These views raise serious concerns that should concern us all, especially at a time when the President continually threatens to fire the leadership of the Department of Justice for failing to be loyal and reining in the Mueller investigation. These views alone are not sufficient for me to vote against Judge Kavanaugh. But what we have seen and experienced in the past several weeks has raised serious new concerns, concerns I believe should worry us all. Judges are expected to be, quote, even-handed, unbiased, impartial, and courteous, end quote. However, at the hearing last week, we saw a man filled with anger and aggression. Judge Kavanaugh raised his voice, he interrupted senators, he accused of Democrats of, quote, lying in wait, end quote, and replacing, quote, advice and consent with search and destroy, end quote. He even went so far as to say that Dr. Ford's allegations were nothing more than, quote, a calculated and orchestrated political hit, fueled with pent-up anger about President Trump and the 2016 election, end quote. Quote, revenge on behalf of the Clintons, end quote. How could he? This behavior revealed a hostility and belligerence that is unbecoming of someone seeking to be elevated to the United States Supreme Court. His display was so shocking that more than 2,400 law professors from around the country have expressed their opposition. They wrote, and I quote, "Instead of trying to sort out with reason and care the allegations that were raised, Judge Kavanaugh responded in an intemperate, inflammatory, and partial manner, as he interrupted and at times was discourteous to senators," end quote. The professors concluded, and I quote, "We have differing views about other qualifications of Judge Kavanaugh, but we are united as professors of law and scholars of judicial institutions in believing he did not display the impartiality and judicial temperament requisite to sit on the highest court of our land. Madam President, I ask unanimous consent to enter a full copy of the letter in the record.
Without objection.
Thank you. Finally, I want to mention the serious and credible allegations raised by Dr. Christine Blasey Ford and Deborah Ramirez, the two women who came forward to tell their experiences facing sexual assault. When Dr. Ford decided to make her story public, she faced all her worst fears. She was harassed, she received death threats, she had to relocate her home, her husband, and 2 children, and yet, in less than a week, she came before the Senate and told 21 senators she had never met, along with millions of Americans, about the most tragic, traumatic, and difficult experience of her life. And she did so with poise, grace, and most importantly, bravery. Unfortunately, she was met with partisanship and hostility. My Republican colleagues have largely chosen to ignore her powerful testimony. Senators weren't allowed to hear from any witnesses who could corroborate or refute her account. They refused to gather evidence or do an impartial investigation into her allegations. Deborah Ramirez also reluctantly came forward to tell her story. Like Dr. Ford, Ms. Ramirez offered to speak to the FBI. Both Ford and Ramirez submitted evidence to support their allegations, including naming over 24 witnesses each. Unfortunately, the limited investigation that was conducted by the FBI failed to interview any one of the witnesses these 2 women identified who could support her account. Let me say that again. They refused to investigate, to talk with any of the 24 witnesses that could have supported their accounts. Mr. President, I think it's important to remember why we're here today. We're here to determine whether Judge Kavanaugh has demonstrated the impartiality, the temperament, the even-handedness that's needed to serve on this great high court of our land. If confirmed, he will join 8 other individuals who are charged with deciding how the laws of our land are interpreted and applied. He would be a deciding vote on the most important issues affecting our country and every American for generations to come. Mr. President, Madam President, based on all the factors we have before us, I do not believe Judge Kavanaugh has earned this seat. Thank you.
Madam President.
Democrat leader.
Thank you, Madam President. Now, Madam President, from start to finish, President Trump's nomination of Judge Brett Kavanaugh to the United States Supreme Court will go down as one of the saddest, most sordid chapters in the long history of the federal judiciary. The well was poisoned from the outset when President Trump selected Judge Kavanaugh from a list of names pre-approved by hard-right special interest groups for whom the national interest is a trifling concern compared to repealing Roe v. Wade, cutting people's health care, and achieving a partisan majority on the Supreme Court. The rot worsened when the Republican majority on the Judiciary Committee shielded the bulk of Judge Kavanaugh's records from the public, discarding decades of bipartisan precedent and thwarting norms of transparency and of fairness. And finally, the dam broke under the weight of credible allegations that Judge Kavanaugh committed a sexual assault in high school. In 2018, the Republican majority conducted a hearing that made the Anita Hill hearings in 1991 look fair by comparison. In this hearing, there were no corroborating witnesses on either side, no independent investigation of the facts to inform the questioning. They even hired an outside counsel to put a witness, Dr. Ford, on trial. Only at the 11th hour, urging of breakaway members of their caucus, Republicans submitted reluctantly to a one-week investigation of the allegations, an investigation which was then severely circumscribed by the White House. Our Republican friends blame us for this process. They're always finding a straw man, but nothing could be further from the truth. First, they blame us for delay, knowing full well that Majority Leader McConnell has complete control of when nominees are brought to the floor. Leader McConnell could have moved this nominee 2 weeks ago or 1 week ago. Democrats had no say, and don't, when it comes to who comes to the floor. But in each case, Leader McConnell couldn't move the nominee forward because he was blocked by fellow Republicans, not Democrats, from moving forward. When it comes to complaining about delay, two words never come from our Republican friends' lips: Merrick Garland. Republicans are also saying we engaged in, quote, a smear campaign or the politics of personal destruction with this nomination. In reality, again, they're using Democrats as a straw man because what they're really talking about is what Dr. Ford said. Democrats did not induce her to come forward. Her conscience did. And our Republican friends, are our Republican friends accusing Dr. Ford and her deeply held memories of what happened to her of a smear campaign? Are they accusing Dr. Ford of a smear campaign? Of engaging in the politics of personal destruction? Because that is who they're actually blaming. They're decrying her testimony and then trying to blame Democrats. I don't blame them. They have a flawed nominee. They don't want the focus on the nominee. When future Americans look back at these proceedings, let them draw no lessons from the Senate's conduct here. Let them look back on this chapter as the shameful culmination of the scorched earth politics practiced by the hard right in America. People who will stop at nothing to entrench an advantage on our nation's courts. Let the confirmation process for Judge Kavanaugh be recorded as a sorry epilogue to the brazen theft of Justice Scalia's seat, the ignominious end of bipartisan cooperation and consultation on the confirmation of Supreme Court justices. And for what? For whom were Senate Republican leaders willing to discard all semblance of fairness to confirm? Judge Brett Kavanaugh, certainly a product of an elite education, but also someone with hard right, conservative jurisprudence, far, far away from what average Americans believe. Why most Democrats opposed his nomination at the outset feels like ancient history now. But let us not forget that, most importantly, we strongly disagree with a number of Judge Kavanaugh's views. He's deeply skeptical of unenumerated rights, including a woman's right to make fundamentally private decisions about her medical care. He's deeply skeptical of the government's role in protecting Americans with pre-existing conditions. He's deeply skeptical of nearly all rules and regulations that protect consumers, workers, the environment. And the flashing red light warning sign at the center of Judge Kavanaugh's jurisprudence are his views on executive power and accountability. Somehow, this conservative judge and scholar of the Constitution sees at the heart of American democracy a president cum king, an executive who's unaccountable to the laws he's sworn to uphold, a head of state who, while in office, should be beyond the reach of subpoenas, criminal investigations, or civil investigations. This moment in American history demands deep skepticism about Judge Kavanaugh's views on executive power, nominated as he was by an executive who disdains the constraints of his office and who is at this very moment the apparent subject of investigations his Supreme Court nominee believes should be invalid. I met with Judge Kavanaugh for almost 2 hours, and I asked him about all of those issues. His answers were constantly evasive and utterly unsatisfactory. It was deja vu all over again in the first round of hearings, when Judge Kavanaugh deliberately avoided talking about his views on Roe, health care, presidential accountability, and more. There was no legal reason, rule, or logic that prevented him from being clear and saying what he thought. He was evasive because he knows that his views are deeply at odds with the progress America has made over the last century of jurisprudence, and at odds with what most Americans believe. His performance was not only unfair and frustrating to the Senate, it was unfair to the American people. When a nominee refuses to disclose their views, chances are you have a nominee whose views are far outside the mainstream of America, whether they be far right or far left. My colleagues on the other side of the aisle may not have as grave a concern about these views as we do, but let no American be surprised if Judge Kavanaugh becomes a decisive vote to restrict the rights and privileges of the American people while stretching the bounds of privilege for the current occupant of the White House. Judge Kavanaugh's nomination ultimately does not only encompass questions of ideology or credentials, but questions of character. Here again, Judge Kavanaugh falls woefully short of what Americans expect and deserve in a Supreme Court justice. He has repeatedly misled the Senate about his involvement in some of the most serious controversies of the Bush administration, including warrantless wiretapping of American citizens, our policy against torture, the theft of electronic records from Democratic senators, and his involvement in the nomination of very controversial judges. Faced with credible allegations of various types of misconduct, Judge Kavanaugh's credibility was again tested, and he continued to dissemble and even prevaricate about easily refuted facts. Beyond the issue of credibility, Judge Kavanaugh presented to the Senate the bitterest partisan testimony I have ever heard coming from a candidate seeking the Senate's approval, whether they be for the bench or the executive branch. Now, there are many who think that what happened when Judge Kavanaugh was 17 years old should not be dispositive. Even if you believe that, his actions at age 53, in terms of demeanor, partisanship, and above all, credibility, should be dispositive. Judges at every level of the federal bench should be held to the highest standard of ethics and moral character. Judges at every level should be judicious and credible and independent, but especially on the Supreme Court. I do not see how it's possible for my colleagues to say with perfect confidence that Judge Kavanaugh has the temperament, independence, and credibility to serve on the United States Supreme Court. So, I ask my colleagues on the other side of the aisle, why Judge Kavanaugh? There is no dictate that you have to march blindly forward with a nominee when there are others available to you. There are many judges who I'm sure conservatives would be happy to have on the court. I'd remind my colleagues, the seat that Brett Kavanaugh aspires to fill was held by a justice who assumed the bench after one nominee was voted down by the Senate and a second nominee withdrew his nomination. But the Republican majority has pressed forward blindly on Judge Kavanaugh, even when brave women came forward to speak truth to power. Why? For what cause? For the sake of winning? That's not reason enough. My colleagues on the other side, if you have doubts about Judge Kavanaugh's credibility, about his ability to tell the truth, about his ability to be impartial and nonpartisan, no matter what you think of his jurisprudence, or what he may or may not have done in high school and college, you should not vote to confirm him to the Supreme Court. So, my friends, Democrat and Republican, for all the controversy, all the heavy-handedness of the process, all the hyperbole and vilification of both sides, there's always hope that the Senate can save itself. We can salvage some decency here at the end. If Judge Kavanaugh is rejected, President Trump will select another nominee, likely right of center, probably not to my liking, but without the cloud that hangs over this nominee. And we can proceed to consider that nominee in a much less bitter, much better, less partisan way. A bipartisan majority of senators, considering fully the weight of Judge Kavanaugh's testimony, record, credibility, trustworthiness, and temperament, considering fully the heartbreaking testimony of Dr. Christine Blasey Ford, can vote to reject Judge Kavanaugh's nomination and ask the President to send the Senate another name. For the sake of the Senate, of the Supreme Court, and of America, I hope, I pray, my colleagues will do so.
Madam President.
The Majority Leader.
It was 88 days ago that President Trump announced his nomination of Judge Brett Kavanaugh to fill the current vacancy on the Supreme Court. Judge Kavanaugh is a nominee of the very highest caliber, a brilliant legal mind, an accomplished jurist with a proven devotion to the rule of law. Today, the Senate has the opportunity to advance his nomination. Every one of us will go on record with one of the most consequential votes you ever cast in the Senate. Now, the stakes are always high for a Supreme Court nomination, but colleagues, the extraordinary events of recent weeks have raised them even higher this time. When we vote later this morning, we will not only be deciding whether to elevate a stunningly well-qualified judge to our highest court, not anymore, not after all this, the United States Senate will also be making a statement. We'll either state that partisan politics can override the presumption of innocence, or we'll reaffirm that in the United States of America, everyone is innocent until proven guilty. We'll either state that facts and evidence can simply be brushed aside when politically inconvenient, and signal that media bullying and mob intimidation are valid tactics for shaping the Senate. The mob can attack, and the Senate caves. Or we'll stand up and say that serious, thoughtful, fact-based deliberation will still define this body. We'll either give notice that totally uncorroborated allegations are now officially enough to destroy an American's life, or we'll declare that our society cannot, must not, will not set the bar so low. So, Madam President, today is a pivotal day in the nomination process of this excellent judge. But it's a pivotal day for us here in the Senate as well. The ideals of justice that have served our nation so well for so long are on full display. So let's step back and sample a few of the choice moments that the Senate and the American people have been treated to during the disgraceful, absolutely disgraceful spectacle of the last 2 weeks. The very night Judge Kavanaugh was announced as the president's choice, we heard the junior senator from Oregon declare that this nominee would pave the way to tyranny. His audience? Crowds of far-left protesters still filling in the blanks on their picket signs. They weren't quite sure who the nominee was going to be yet. We've heard the junior senator from New Jersey describe Judge Kavanaugh's nomination as a great moral struggle in which there are just two camps. You're either complicit in the evil or you're fighting against it. More recently, we've heard the junior senator from Hawaii argue that her personal disagreement with Judge Kavanaugh's judicial philosophy meant, now listen to this, he deserved less of a presumption of innocence when it came to allegations of misconduct. If you disagree with her, you're not entitled to the presumption of innocence when it comes to allegations of misconduct. That's from a member of the Judiciary Committee? That's the definition of due process? Apparently you get due process only if you agree with her. And even more recently, we saw the junior senator from Rhode Island hold forth with great confidence, offering his expert interpretations of goofy jokes in high school yearbooks from the early 1980s. That was incredibly enlightening. Innocent jokes? Beer drinking references? Oh, no. Our colleague was quite positive there must be some other hidden or sinister meanings at play. Until, of course, a number of Judge Kavanaugh's classmates set him straight earlier this week. So stop and consider these snapshots. The absurdity, the indignity. This is our approach to confirming a Supreme Court justice. This is the Senate's contribution to public discourse? Before the ink had dried on Justice Kennedy's retirement, our Democratic colleagues made it perfectly clear what this process would be about: delay, obstruct, and resist. And before the ink had dried on Judge Kavanaugh's nomination, colleagues across the aisle, including Democratic members of the Judiciary Committee, were racing to announce they'd made up their minds and were totally opposed to his confirmation. Mere hours after Judge Kavanaugh was nominated, my friend, the Democratic leader, promised, quote, "I will oppose him with everything I've got," he said, hours after he was nominated. It was thus abundantly clear that his number one political goal was to defeat the nomination by any means necessary. It was right there from the beginning, Madam President. A clear declaration, plain as day, nothing could get most Democrats to consider this nominee with an open mind. It would be delaying tactics, obstruction, and so-called resistance until the final vote was called. For a few weeks, their efforts played out along lines that sadly have become somewhat ordinary around here. There were excuses for delay. Those fell flat. There were gross distortions of Judge Kavanaugh's record that were batted down by outside fact checkers. And there were all the usual phony apocalyptic pronouncements that are shouted whenever a Republican president dares to nominate a Supreme Court justice. Happened every time. Hostile to women, hostile to vulnerable people, hostile to workers. Same old tricks, same old playbook. But here was the problem. The old plays weren't working. The distortions were being literally drowned out by the facts. Senators received and reviewed more pages of background materials on Judge Kavanaugh's nomination than for every previous Supreme Court nomination combined. We read Judge Kavanaugh's 12-year record of judicial rulings from our nation's second highest court, 300+ opinions. We heard sworn testimony, written accounts from hundreds of character witnesses from all stages of Judge Kavanaugh's life and career. And the picture painted by these facts was nothing like the caricature. Nothing like the caricature. So it was clear, Madam President, the old tactics weren't working. Wasn't going to get the job done. The resistance demanded more. Try something new, they said. Well, we all know what happened next. Uncorroborated allegations of the most sensitive, most serious sort were quickly sharpened into political weapons. One such allegation, shared by Dr. Ford in confidence with the Democratic side of the Judiciary Committee, somehow, mysteriously, found its way into the press. Well, Chairman Grassley immediately set out on a sober, focused search for the truth. The committee collected testimony, organized a new hearing, and most recently asked for the supplemental FBI background investigation, Judge Kavanaugh's seventh FBI investigation. By any fair standard, the facts, the actual facts, proved to be straightforward. No corroborating evidence, none, was produced to support any of the allegations leveled against Judge Kavanaugh. No corroborating evidence from the FBI inquiry or from anywhere else. Nothing. Well, that wasn't enough for our Democratic colleagues, of course. The facts were not exactly the point. After all, we sort of get it by now. When the very FBI investigation for which they'd been clamoring turned up no new evidence, the Democrats moved the goalposts yet again. I believe the latest story is that the whole investigation is invalid. Now listen to this, because individuals who had only recently been told secondhand or thirdhand about nearly 40-year-old allegations weren't treated as essential witnesses. Let me say that again. The latest story is that the whole investigation is invalid because individuals who had only recently been told secondhand or thirdhand about nearly 40-year-old allegations weren't treated as essential witnesses. Never mind that they didn't actually witness anything. They didn't witness anything. So let's be clear, Madam President, these are not witnesses. These are people supposedly in possession of hearsay that they first heard 35 years after the supposed fact. What nonsense. The people whom Dr. Ford claimed were witnesses, they have spoken with the FBI. We know that because they, through their attorneys, put out public statements saying so. And what we know now is what we knew at this time a week ago. There is absolutely no corroborating evidence for these allegations. Same thing we heard a week ago. If they were, you bet we'd have heard about it, but there isn't. So notwithstanding that, Madam President, the leak of Dr. Ford's letter in violation of her privacy and against her wishes opened the floodgates. The feeding frenzy was full on. The weaponization of her letter by the left led to a torrent of other equally uncorroborated allegations. They were dumped on Judge Kavanaugh and his family. And breathlessly, the media seized on them. The more outlandish, the better. Americans were informed that Judge Kavanaugh masterminded violent drug gangs as a young teenager until that accuser walked her story back. We were informed that Judge Kavanaugh beat someone up on a boat in a Rhode Island harbor until that accuser totally recanted. We heard another tall tale of physical assault until that account was thoroughly debunked by a sitting federal judge. Oh, and yes, we were informed that juvenile jokes in his high school yearbook were actually sinister, secret references. All the Keystone cops were on the case. Keystone cops were on the case, Madam President. And Senate Democrats cheered them on. They read parts of this uncorroborated, unbelievable mudslide into the Senate record. They cited them in an official letter demanding that Judge Kavanaugh's nomination be withdrawn. Were they true? Well, of course, that was quite beside the point. Quite beside the point. So long as they were convenient. Every effort was made to ensure that the fact-free verdict of the mob and the media would win out over the actual evidence. Make sure the mob prevails. But the uncorroborated mud and the partisan noise and the physical intimidation of members here in the Senate will not have the final say around here. The Senate will have the final say. So, Madam President, we're almost at the end of the runway. The crosswinds of anger and fear and partisanship have blown strong these past weeks. They've harmed a good man and his family. They've tarnished the dignity of this institution. But all of it can end today. The time has come to vote. The Senate stands on the threshold of a golden opportunity. We have the opportunity to advance the nomination of an incredibly well-qualified and well-respected jurist to a post that demands such excellence. We have the opportunity to put Judge Brett Kavanaugh on the Supreme Court, where his distinguished service will make us and our nation proud for years to come. But we have the opportunity to do even more. Today, we can send a message to the American people that some core principles remain unfettered by the partisan passions of this moment. Facts matter. Fairness matters. The presumption of innocence is sacrosanct. The Senate has turned its back on these things before, Madam President, but never for long, and never without deep regret. This institution does not look back proudly on the era of Joseph McCarthy, nor on any of the other times when the politics of personal destruction poisoned its judgment. No, the Senate looks back on those things with shame and with a conviction that we cannot go down that road again. We know the Senate is better than this. We know the nation deserves better than this. By confirming Judge Brett Kavanaugh to the Supreme Court, this brilliant jurist will be charged with upholding the rule of law and honoring American justice. We must hold ourselves to that very same standard. We must seize the golden opportunity before us today to confirm a Supreme Court justice who will make us proud, and to reaffirm our own commitment to the justice that every single American deserves.
As a reminder to our guests in the galleries, expressions of approval or disapproval are not permitted in the Senate galleries. The clerk will report the motion to invoke cloture.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, do hereby move to bring to a close debate on the nomination of Brett M. Kavanaugh to be an Associate Justice of the Supreme Court of the United States, signed by 17 senators.
Unanimous consent, the mandatory quorum call be waived.
Is there an objection? Without an objection. By unanimous consent, the mandatory quorum call has been waived. The question is it the sense of the Senate that debate on the nomination of Brett M. Kavanaugh of Maryland to be an Associate Justice of the Supreme Court shall be brought to a close? The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Corker. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Crapo. Mr. Cruz. Mr. Daines. Mr. Donnelly. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Mrs. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Flake. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hatch. Mr. Heinrich. Ms. Heitkamp. Mr. Heller. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Isaacson. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Kyle. Mr. Lankford. Mr. Leahy. Mr. Lee. Mr. Manchin. Mr. Markey. Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Nelson, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott, Mrs. Shaheen, Mr. Shelby, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young, Senators voting in the affirmative: Alexander, Barrasso, Blunt, Bozeman, Burr, Capito, Cassidy, Collins, Corker, Cornyn, Cotton, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Flake, Gardner, Graham, Grassley, Hatch, Heller, Hoeven, Hyde-Smith, Inhofe, Isaacson, Kennedy, Kyle, Lankford, McConnell, Moran, Paul, Perdue, Portman, Risch, Roberts, Rounds, Rubio, Sass, Scott, Shelby, Sullivan, Thune, Tillis, Toomey, Wicker, and Young. Mr. Manchin, aye. Senators voting in the negative: Baldwin, Bennett, Booker, Brown, Cantwell, Cardin, Casey, Coons, Cortez Masto, Duckworth, Durbin, Feinstein, Gillibrand, Harris, Heinrich, Kane, Klobuchar, Leahy, Markey, Merkley, Murkowski, Murphy, Murray, Nelson, Peters, Schatz, Smith, Stabenow, Tester, Udall, Warner, Warren, Whitehouse, and Wyden. Mr. Sanders, no. Mr. Lee, aye. Ms. Hassan, no. Mr. Jones, no. Mr. Johnson, aye. Mr. Schumer, no. Mr. Donnelly, no. Ms. Heitkamp, no. Mrs. McCaskill, no. Mr. Menendez, no. Mr. Reed, no. Mr. King, no. Mr. Van Hollen, no. Ms. Hirono, no. Mr. Blumenthal, no. Mrs. Shaheen? No. Mr. Carper?
Senator is not recorded.
I vote no.
Mr. Carper? No.
Are there any senators in the chamber who wish to change their vote? As a reminder to our guests in the galleries, expressions of approval or disapproval are not permitted in the Senate galleries. On this vote, the yeas are 51, the noes are 49. The motion is agreed to.
Madam President.
Senator from Texas.
Madam President, I'd ask unanimous consent that the quorum call be dispensed with.
Senate's not in a quorum call.
Thank you, Madam President.
Senators recognized.
Madam President, could we have order in the Senate, please?
Senate will be in order.
Madam President, as the world knows now, we just held a successful cloture vote on the nomination of Brett Kavanaugh to become the next Associate Justice on the United States Supreme Court. And I'm glad we were successful in closing off debate. We now know that under the Senate rules, 30 hours are available for senators to debate, and I'm sure there will be many senators who will be coming to the floor and offering their thoughts. But to my mind, what the Senate just voted for was to end the games, the character assassination, and the intimidation tactics that unfortunately have characterized so much of this confirmation process. Our vote today was important not only because it will allow us to move forward and conclude this confirmation process, but it was important because it showed that the United States Senate will not be intimidated. We will not be bullied by the screams of paid protesters and name-calling by the mob. We will not be complicit in the attempts to tarnish a good man's character, destroy his career, and further delay this confirmation process, a constitutional process of advice and consent. What has been particularly galling on the part of some of our colleagues over the last 24 hours is the fact that the FBI investigation that they called for, they are virtually ignoring, or in some cases disparaging. They called for that supplemental background investigation just last Friday. Let's all remember what our friend, the senior senator from Minnesota, said, for example, last weekend. She said, let's give this 1 week. Well, that's what we gave them. The junior senator from Delaware asked for the same period of time at the hearing, a 1 week long FBI investigation. So our colleagues got what they asked for, and unfortunately, since they had already decided to vote against the nomination, they must have been somewhat disappointed that the supplemental background investigation came up with no new information, no corroboration at all. Now, I actually think in some ways our colleagues who called for a 1 week delay have done us a favor, because every lead that could be followed has been followed and exhausted. And as the majority leader was saying earlier, in America, under our constitutional system, where we don't presume that you're guilty and require you to prove your innocence, and where we believe in due process of law, I think the FBI investigation was a useful way to demonstrate to the American people that none of these allegations that have been made against Judge Kavanaugh of sexual misconduct have been proven. It also, I think, gives us a chance to pivot from what has been a shameful and disgraceful confirmation process. If this is the new norm for the Senate, that somebody could be denied a confirmation based on an unproven allegation, I can't imagine people being willing to subject themselves to that in the future. And it would be a dark day for the Senate and for the United States and for our system of justice that believes in a fair process and a constitutional presumption of innocence. And when an allegation is made, that the person making that allegation actually has to come forward with some evidence. A number of senators, actually it was a bipartisan consensus, wanted the FBI to conduct a limited investigation into current credible allegations that were pending. They wanted the FBI to interview individuals like Mark Judge, who had already offered a sworn statement under penalty of felony, and others who may have had information that were identified by Dr. Ford as being present on the day that this alleged activity took place. There was no confirmation, there was no corroboration. In fact, there was a refutation. The people she said were there and could be witnesses, were witnesses to what happened, said, I have no knowledge of that. Dr. Ford's best friend, Leland Kaiser, said, I don't even know Brett Kavanaugh. I've never met him. Well, we've all had an opportunity to read the confidential report. We've seen who was interviewed, what they were asked, and any doubts that people may have had should now have been put to rest by what the contents reveal. These fantasies about Judge Kavanaugh being some sort of serial high school or college predator have been exposed as only that, myths, not based on fact. There's no reliable evidence whatsoever to support any of these baseless allegations against Judge Kavanaugh. But as we know, this wasn't exactly designed to be a truth-finding process. This wasn't a search for the truth. Our colleagues across the aisle had already made up their mind a long time ago, some even before Judge Kavanaugh had been nominated. This was more of a, as the majority leader said earlier today, not a search for the truth, but a search and destroy mission. And obviously, as they continue to move the goalposts, calling for more delays, more investigations, there's been 7 background investigations by the FBI of Judge Kavanaugh during his public service. The FBI has talked to more than 150 witnesses. Don't you think if there were anything to these outrageous allegations that some of that would have come up at some point in the 7 FBI background investigations that have been conducted? But our colleagues across the aisle continue to resist putting a definitive end to this process. And unfortunately, caring little, if any, about the reputation of somebody who has demonstrated his outstanding qualifications and his commitment to public service. I think some of these attacks have become exhausted, politically exhausted, frankly. Our colleagues don't seem to realize what they have unleashed. When senators get coat hangers mailed to their home, protesters, paid protesters, show up on their doorstep or at their office, or are accosted in the halls of the United States Congress. Paid protesters who reportedly, once they get arrested, actually make more money from their funders than they do if they don't get arrested. That is what has been unleashed. Chairman Grassley called it mob rule. That's exactly right. Where the Judiciary Committee, during the first confirmation hearing for Judge Kavanaugh, where senators said, I'm breaking the rules. I'm releasing committee confidential information I know the rules prohibit me from doing. And they don't care. If there are no rules and there are no norms, and if we don't have enough respect for this institution and the people whose lives we touch, this is what gets unleashed. I feel badly for Dr. Ford in particular. She wanted none of this three-ring circus. She sent a letter to the ranking member and asked that her identity remain confidential, only to find after the first confirmation hearing that it was leaked to the press. And then the press came to talk to her, and I guess she figured she had nothing else, no other recourse but to actually tell her story to the press once her wishes were violated. She didn't consent to that. She didn't authorize the release of that confidential letter where she to the press, but that's what happened. When we gave her an opportunity to have a bipartisan professional investigation staff come out to California and interview her confidentially, she said, nobody explained to me that was an option. Well, the lawyers that the ranking member referred her to apparently didn't even tell their own client that she had the opportunity to avoid this three-ring circus and the embarrassment associated with it by doing something confidentially. That's how the Judiciary Committee ordinarily operates when allegations are made. They're investigated by committee staff or by the FBI actually by both. But that didn't happen here until after this mob rule unleashed what we've seen here in the last few weeks. We know that when Dr. Ford sent her letter to the ranking member, that it wasn't shared with the FBI initially, wasn't shared with Judiciary Committee investigators, it wasn't shared with the committee itself in a closed-door session, which followed the open session where Judge Kavanaugh was asked about other personal matters that came up during the course of the background investigation. The ranking member didn't even attend that closed-door session, nor did anybody mention it to the judge when he went to talk to some 60-plus members of the Senate one-on-one. The ranking member, when she had that one-on-one meeting with Judge Kavanaugh, she said nothing to him about the allegations. She could have asked him about the allegation generally without revealing the identity of Dr. Ford. We know at that point she'd already talked to Dr. Ford and recommended partisan lawyers. We know that those lawyers arranged for a polygraph examination to be administered. Other preparations were being made, plans were being hatched. And our colleague from California said nothing. I really think that Dr. Ford has been treated terribly by this ambush, by this hiding evidence and allegations that could have been investigated, should have been investigated in a more dignified and appropriate sort of way. Once Dr. Ford was identified, in consultation with colleagues, both Republicans and Democrats, we decided that Dr. Ford should be given an opportunity to tell her side of the story. Unfortunately, we weren't able to mitigate or reverse a lot of the awful circumstances under which she found herself because of what had already been unleashed, but we did our best. We tried to do whatever we could to accommodate her. As I said, investigators offered to come to California. We brought in an experienced sexual crimes investigating attorney to ask questions in a respectful and sort of way to elicit as much information as we possibly could get about her claim, even though it was 35 years old. Throughout the hearing, we listened to Dr. Ford, and we tried to understand what she was telling us. We took her allegations seriously and treated her the same way we would want our wives or our daughters treated if they found themselves under similar circumstances. But we know what, at the end of the day, there's no other witness who could corroborate or confirm what she said, even the ones that she identified as having been present. This is not about believing women or believing men. It's not a zero-sum game. As the junior senator from Nebraska said the other day, it's not about being for the Me Too movement or against it, but who could be against it? I hope there's some good that comes out of this disgraceful display. One of the things that might be good be that more women would feel confident to come forward and tell their story to the appropriate authorities and produce the sort of information that would be necessary to make a criminal case, to investigate the case, to charge the case, to try the case, and to convict people who commit sexual offenses. I hope there's some good that comes out of this. There's also maybe some legislation that we could work together on to try to heal the wounds that have been caused by this abominable process. I've worked a lot with colleagues here to pass anti-human trafficking legislation, to end the rape kit backlog, and to do other things to try to help victims. And I think maybe, just maybe, putting our heads together, talking with each other, working in good faith, we could come up with some legislative response that might find some good out of this terrible situation. The other thing about these allegations made against Judge Kavanaugh is they are completely out of character. We know he's been a circuit court judge for 12 years, authored more than 300 opinions, clerked for Anthony Kennedy on the Supreme Court, worked at the White House as a lawyer and staff secretary for the president. He's taught at Harvard. He was hired by now Justice Elena Kagan to teach at Harvard, as well as teaching at Georgetown and Yale. And by all accounts, every account of anyone with personal knowledge of Judge Kavanaugh's character and treatment of women, they all say he treated women with respect. It's not just conservatives that sing his praises. A liberal law school professor at Yale called Judge Kavanaugh's selection the president's finest hour, his classiest move. The same professor complimented Judge Kavanaugh's studiousness and said he's already shown flashes of greatness. Lisa Blatt, a self-described liberal feminist lawyer who's argued numerous cases before the U.S. Supreme Court, has said Judge Kavanaugh is supremely qualified. That echoes what the American Bar Association, the gold standard for some of our colleagues when it comes to judicial nominees. The American Bar Association has said that Judge Kavanaugh is unanimously well qualified, and that goes for his temperament as well. So I believe this nominee is about as good as it gets. July 10th, the day after Judge Kavanaugh was nominated, I said that my Republican colleagues and I won't back down from this all-out assault on this nominee. But never in my wildest dreams could I have imagined that this fight would devolve into the mob rule that we've seen. Senators and staffs taunted, threatened, millions of dollars spent in advertising, in paying protesters to show up on senators' front lawns, harass them at restaurants, and attack them in the halls of the Congress. I never imagined this would get this bad, where senators would say, "I'm breaking the rules," and dare anybody to do anything about it. This has turned into the kind of nasty and venomous politics that I hoped never to experience. This also has demonstrated the dark underbelly of Washington, D.C., where power is so important to some people, they will do anything to get it. They will destroy you. They will tarnish your good name. They will condone threats on family members, including children. They will harass you. This has really been disgusting. I'm an optimist, Madam President, so I don't believe that this is our fate. I don't believe we're condemned to work in a Senate and live in a country where this kind of activity is condoned or ignored. I actually think by defeating Judge Kavanaugh's nomination, we would be signaling that this is somehow the new normal. We would be setting a precedent that, yeah, that kind of stuff works, so let's try it again. And I'm not just saying one party or the other. The day after Judge Kavanaugh was nominated, I also said, we will defend the record of Judge Kavanaugh, who is a thoughtful public servant, against deliberate attempts to denigrate him. I stand by that statement, and we have defended him, but not just defended him, but defended the Constitution, fundamental notions of fairness and fair play that are reflected in our commitment to due process of law. and the rights of somebody accused of a crime, which Judge Kavanaugh has been accused of on multiple occasions. Even as the mud has been slung on all of us, even as insults have been hurled against this nominee and his family has faced ridicule over atrocious exploits that never even happened, at least I think we can be proud of the fact we've tried to defend the Constitution, this institution of the Senate, and push back with everything we have against mob rule. Unfortunately, those who wanted to take down this nominee have viewed Judge Kavanaugh as a sacrificial lamb in some sort of vengeance campaign, but thankfully, they've now failed to stop his nomination from going forward. This nomination is no longer simply about Judge Kavanaugh and the current vacancy on the Supreme Court. It's also about the principles we must stand up for and defend. It's about validating public service and decades of honorable conduct. It's not about forgetting all that a man has done, all that he is, and all that he's worked for at the drop of a hat, based on unsubstantiated, uncorroborated allegations. It is about standing firm in the turbulent political winds. And if I think about any institution in this country, I think the Senate ought to be the place where that standing firm against the turbulent political winds occurs. We all had a chance to read the FBI report, which failed to corroborate Dr. Ford's allegations. And then today we did exactly what we needed to do, which is to vote. To stop the circus, to stop the hijinks, stop the character assassination, and vote. So I'm glad our colleagues decided to close off debate now as this 30-hour post-cloture period ensues. I look forward to concluding the confirmation process and confirming Judge Kavanaugh to be the next Associate Justice on the United States Supreme Court.
Madam President.
Senator from Illinois.
Madam President, I'd like to respond to my colleague from Texas, at least one or two aspects of what he has said. He has characterized the opposition to Judge Kavanaugh as mob rule. I don't think that's a fair characterization. The opposition to Judge Kavanaugh comes at many different levels. My colleagues on both sides of the aisle, I believe, have looked at this nomination seriously, and they've come to opposite positions. I don't believe we are influenced, frightened, or in any way moved by mob rule. I just don't get it. Now, have I seen conduct by people who feel strongly about this issue that I think is untoward and really should not be condoned? Of course. Do I believe that people should have their freedom of speech limited or stifled? No, I don't. Even if it's something I don't want to hear, people have a right to speak. Of course, I will never condone violence or any physical activities against anyone, including members of Congress. And some people have either come close to that line or stepped over it. I don't defend that in any way, shape, or form. But if we are truly committed to the Constitution we've sworn to uphold and defend, that First Amendment creates opportunities for American citizens which others around the world long for and never see once in their lives. Part of that is freedom of speech. Part of that is the right to petition your government. So if some have stepped over the line, I won't defend them when it comes to violent conduct. But in expressing their point of view with a sign or a march or even a chant, I have to say that is part of our constitutional birthright, thank goodness, in the United States of America. Last week I saw Dr. Christine Blasey Ford for the first time. I'd heard her name for a week or more. I'd seen one photo of her in sunglasses. I'd never seen her or heard her speak. She came forward at great risk to herself and to her family after having been dislocated from her 2 different homes with her kids. And she came here to face the Senate Judiciary Committee and the nation and to speak under oath. She had absolutely nothing to gain by coming forward. She did it, as she said, out of a sense of civic duty. She wanted to, in her own words, be helpful, so the Senate and leaders of this nation would know what happened to her before any vote on the confirmation of Brett Kavanaugh to the Supreme Court. Her testimony was credible and powerful. She answered every question, trying to be helpful whenever she could. I was struck by the statement from the senator from Texas. He said, some way we want to make sure that our wives and daughters are going to be treated fairly if they come forward with this kind of information. I couldn't agree with him more. But we all know what happened after her testimony. Even President Trump, before a Mississippi rally, ridiculed and belittled Dr. Ford. After having called her once a credible witness, she became the butt of his joke at a rally in Mississippi. That's unfortunate. When Dr. Ford came before us, she had nothing to hide. And the Republicans on the committee were so concerned about her testimony and their relationship in questioning her, they were unwilling to risk direct questioning as she sat in front of them. They pointedly enlisted a woman prosecutor to do their job. The prosecutor's examination was meandering and without any clear focus other than an attempt to try to discredit Dr. Ford. That Republican prosecutor failed, as Dr. Ford calmly replied to all of her questions. It was clear, however, that despite this testimony, even despite this hearing, many Republicans had made up their mind, as the majority leader characterized it, to plow right through, regardless of Dr. Ford's testimony. We hear so many tributes to Dr. Ford now from the Republican side out of one side of their mouth, and then they turn around and say, it's a smear. A smear is a lie. I don't believe she was lying. They can't praise her on one hand and call her testimony a smear on the other. And the majority leader did that 3 successive days on the floor of the United States Senate. They even went so far as to schedule a committee vote before that hearing with Dr. Ford and Judge Kavanaugh had started. Then last Friday, 2 of our colleagues, Republican Senator Jeff Flake, Democratic Senator Chris Coons, came together and joined Dr. Ford's call for a nonpartisan, thorough FBI investigation into the pending allegations against Judge Kavanaugh. That should have happened long before. But make no mistake, there would not have been a hearing with Dr. Ford were it not for Senator Flake demanding it, a Republican senator demanding it, and there would not have been an FBI investigation if he hadn't demanded it as well. I thank him for his leadership in doing that. Those were 2 reasonable requests, and I'm glad that he was in a position to make it happen where Democrats could not. It was the right request. Of course, it would have been helpful for senators exercising our advice and consent role if neutral investigators at the FBI were allowed to question all the relevant witnesses, follow the facts wherever they may have led, and get to the bottom of the allegations brought by Dr. Ford, Deborah Ramirez, Julie Swetnick. Unfortunately, the White House and Senate Republicans were determined not to let such an FBI investigation go forward. White House spokesman Shah has now publicly acknowledged that Senate Republicans were allowed to severely constrain the scope of the FBI investigation. He said it. He said it publicly. He said it before the cameras. Senate Republicans only allowed a handful of witnesses to be interviewed by the FBI. Deputy Press Secretary Raj Shah said, and I quote, there was an initial list of four provided to us by the Senate. There were reportedly almost 40 corroborating or character witnesses who've been trying to share information with the FBI. The FBI has refused to contact them, even though their names have been provided. Dr. Ford's and Deborah Ramirez's attorney both sent letters yesterday with lists of corroborating witnesses who were not interviewed by the FBI. There were only 10 witnesses interviewed. There is no good explanation why these witnesses weren't interviewed by the FBI. Nor can I explain why Dr. Ford and Judge Kavanaugh themselves weren't interviewed. Those are basic to a legitimate, credible investigation. Some of my Republican colleagues have claimed that the FBI's supplemental investigation provides no corroboration of Dr. Ford's or Ms. Ramirez's complaints. But of course, you won't find corroboration if the investigation systematically excludes corroborating witnesses. Unfortunately, the effort by the White House and Senate Republicans to tie the FBI's hands in the Kavanaugh investigation is part of a pattern of concealment when it comes to the background of Brett Kavanaugh. The senator from Texas says, I hope this isn't a new standard for hearings on Supreme Court nominations. I hope it isn't either. There are some things which we've done in this particular nomination hearing that were unheard of. Millions of pages of Judge Kavanaugh's public service record have been blocked from release to the public and even to the Senate. There was a time when Senator Jeff Sessions, now Attorney General, demanded documentation on Democratic nominees, and at that time, the Democratic ranking member and chairman agreed with him. We provided all the information requested, as we should. In this case, with Republican control of the committee, we were limited. We've been denied access to an entire 35-month period in Judge Kavanaugh's White House career when he worked as one of the president's closest advisors, the White House staff secretary. He worked during that time on controversial issues like same-sex marriage, abortion, torture, and executive power. It's likely that there are documents in Kavanaugh's staff secretary record that would impact how senators would vote on his nomination, and that's why they were hidden. There's also an unprecedented partisan effort to screen and limit the documents that the committee itself could see. I listened as the senator from Texas said, well, Dr. Ford had a partisan lawyer. Guess who screened the documents that were going to go from the official records to our Judiciary Committee to review for that nomination of Brett Kavanaugh? The man's name was Bill Burke. Bill Burke, by every measure, is a partisan lawyer. I guess it's no surprise. What I was surprised is to find an individual lawyer would have such power over a constitutional provision of advice and consent. Overall, when all was said and done, after the denials from the White House of certain records, after the claims of executive privilege, after Bill Burke went through and screened what he considered to be appropriate and inappropriate documents for the American people to see, less than 10% of Judge Kavanaugh's White House record has been disclosed. Those documents are going to come out someday. And those who are quickly voting for him now without reading him run the risk that they're making a mistake, which they're going to have to explain at a later time. Just yesterday, we learned from a FOIA lawsuit that the National Archives has hundreds of documents concerning Brett Kavanaugh's work in the White House on warrantless surveillance programs. We won't see those documents before tomorrow's vote. The White House apparently fears their contents and prefers to plow through. Why has so much of Judge Kavanaugh's record been concealed? Most likely because these documents contradict what he has said. We've seen a pattern with Judge Kavanaugh from his Senate testimony in 2004, 2006, and again last month. When he's asked about controversial issues that he's been involved in the past, he tries to deny or downplay them. He's done this repeatedly when testifying about matters he worked on at the White House, including the rules governing detention of combatants, warrantless surveillance, controversial judicial nominations like Pryor, Pickering, and Haynes, communicating with the press during the Starr investigation, and his work with Manny Miranda, a Republican Senate staffer who stole documents from Democratic senators' computers, including my own, and shared them with Brett Kavanaugh when he was working in the White House. On each issue, we've seen documents or reports showing that Judge Kavanaugh had far more involvement than his testimony let on. On issue after issue, Judge Kavanaugh's sworn testimony was either misleading or false. This is a judge who claims that words matter. He says he's a strict textualist who holds other people accountable for their words. But when it comes to his own words, he's happy to take liberties and refuse to take responsibility. We've been forewarned of what we can expect if he's given a lifetime appointment on the court. We saw this pattern again last week when he was asked questions about his high school yearbook and excessive drinking. They were legitimate questions that were relevant to the sexual assault allegations at hand. Many of Kavanaugh's answers to these questions simply weren't credible. His explanation of things he wrote in the yearbook didn't pass the laugh test. And multiple people who knew him and socialized with him quickly, publicly rebutted his denial that he ever drank, in their words, quote, to the point that it would be impossible for him to state with any degree of certainty that he remembered everything that he did. I was particularly struck when Senator Amy Klobuchar of Minnesota explained that she understands alcohol abuse because her father was an alcoholic, and then asked Judge Kavanaugh if he'd ever blacked out. Instead of responding, Kavanaugh said, "Have you?" Conservative columnist Jennifer Rubin has written, "It was a moment of singular cruelty and disrespect." It's been hard to take Judge Kavanaugh's testimony at his word on matters both large and small. That matters a lot when we're talking about a nominee's judgment, temperament, and integrity. Judge Kavanaugh's judicial record and his academic writings raise even more concerns. Not only did he check the box on President Trump's litmus test of opposition to the Affordable Care Act and Roe versus Wade, his judicial opinions consistently find ways to favor big business and undermine protection for workers, consumers, women, and the environment. He claims to be a textualist, but he has a habit of creatively defining words. The agri-processors case, which I asked him about directly at the hearing, his dissent abandoned the text of a controlling statute. Instead, he borrowed a definition from another statute in order to argue against the right of slaughterhouse workers to vote to form a union. When I asked Judge Kavanaugh whether he ever worked in a job himself that was dirty and dangerous as a slaughterhouse, he told me he used to cut grass and worked one summer in construction. Or look at his dissents in White Stallion and Mingo Logan cases, where the judge gave his own definitions to key terms in the Clean Air and Clean Water Act. So much for stare decisis. Judge Kavanaugh claims he follows precedent, but we've seen in case after case, he goes his own way. Look at his interpretation of the Supreme Court's 2008 Heller decision. Judge Kavanaugh believes the Supreme Court created a history and tradition test for considering challenges to gun safety laws. This test would have courts ignore the public safety impact of gun laws. Judge Kavanaugh admitted that he's, quote, a lonely voice in reading Heller that way. His approach would put at risk many common sense laws, such as keeping guns out of the hands of domestic abusers. Judge Kavanaugh is not a lonely voice on gun safety. He's an extreme and frightening voice on gun safety. After he wrote a dissent laying out his interpretation of the Heller precedent, a majority panel of D.C. Circuit judges, all of them Republican appointees, said this of his interpretation, quote, unlike our dissenting colleagues, we read Heller straightforwardly. Judge Kavanaugh's reading of Heller may be music to the ears of the gun lobby, but it's manipulating precedent, nothing else. Judge Kavanaugh's claim that he follows precedent is also contradicted by his view of the Supreme Court decision in Morrison versus Olson. Rather than admit the majority's decision in the case still holds, Judge Kavanaugh clings to Justice Scalia's dissent, which lays out the so-called unitary executive theory of presidential power. Judge Kavanaugh's been explicit. He'd overturn Morrison. So let's be clear. While Judge Kavanaugh may claim that he'll scrupulously follow precedent, he's shown he's willing to overturn it when it suits him. I've cited just a few examples. The one that's particularly troubling is this judge's view of presidential power. Judge Kavanaugh wrote a striking passage in the Seven Sky decision, dissenting from majorities upholding the Affordable Care Act. He wrote, and I quote, under the Constitution, the president may decline to enforce a statute that regulates private individuals when the president deems the statute unconstitutional, even if a court has held or would hold the statute constitutional. This is a truly breathtaking claim of presidential power, a claim particularly problematic at this moment in history. And then there's Judge Kavanaugh's evolving view on investigations of sitting presidents. When he was working for Ken Starr and investigating President Clinton, he was pretty ferocious. In 2008, he gave a speech and said that he argued now that sitting presidents should be immunized from criminal investigation in civil suit. This was after Judge Kavanaugh spent a period of time working in the Bush White House. He claims he has an open mind on the constitutionality of criminal investigations of sitting presidents, but consider what he wrote in that law review article in the Minnesota Law Review. I quote, "If the president does something dastardly, the impeachment process is available. No single prosecutor, judge, or jury should be able to accomplish what the Constitution assigns to Congress. These are not the words of a judge with an open mind." And it was a telling moment when Judge Kavanaugh would not answer at his hearing whether he believed a president should comply with a grand jury subpoena. Here's the reality. We have to consider why this president chose this Supreme Court nominee at this moment in history, when the Mueller investigation is closing in. Judge Kavanaugh himself said just a few weeks ago, and I quote, "The Supreme Court must never be viewed as a partisan institution. But the testimony and demeanor of Judge Kavanaugh last Thursday belies any claim he makes of nonpartisanship. I can understand emotion and indignation from Judge Kavanaugh when one considers the gravity of the charges against him and the pain he and his family must feel. But there was fire in his eyes when he read the words he assured us he had personally written. Benjamin Wittes has been a colleague of Brett Kavanaugh. He's published his writings, and he even lent his name as a character reference for the judge. He called Judge Kavanaugh's performance before the Senate Judiciary Committee, and I quote, "a howl of rage." Wittes went on to describe Kavanaugh's partisanship as, quote, "raw, undisguised, naked, and conspiratorial." Charlie Sykes, a conservative commentator, said of Kavanaugh's statement before the committee last Thursday, quote, "Even if you support Brett Kavanaugh, that was as breathtaking as an abandonment of any pretense of having a judicial temperament." Judge Kavanaugh abandoned any veneer of neutrality last week before our committee. Out of one side of his mouth, he claimed that he bore no ill will toward Dr. Ford. Then he called her allegations, quote, "a calculated, orchestrated political hit," citing apparent pin-up anchor about President Trump and the 2016 election, and revenge on behalf of the Clintons. He even threatened the Democrats, and I quote, when he said, "what goes around comes around." In my 20 years on the Judiciary Committee, I've never heard anything like that, or even close to that, from a judicial nominee. It's hard to imagine how a nominee who has displayed such raw partisanship could then claim to serve as a neutral umpire in the Supreme Court. Judge Kavanaugh, through his testimony, has called his own impartiality into serious doubt. Retired Supreme Court Justice John Paul Stevens, a man who is respected for his integrity and service to this nation, said this week that the performance by Judge Kavanaugh shows he should not serve on the Supreme Court. I agree. At a time when our president plumbs the depths of bad behavior on a daily basis, we should not allow the highest court in our land to now sink to that same standard in their ranks. From a broader perspective, let's be clear what's at stake in this decision. We're in a moment in American history where our system of checks and balances is being profoundly tested. We have a president who has shown disrespect for the rule of law and the role of an independent judiciary. It's likely the Supreme Court will soon consider fundamental questions about presidential authority and accountability. With so much at stake, we should not confirm a nominee to the court unless we are sure of that nominee's credibility, integrity, independence, and judgment. Serious questions have been raised about Brett Kavanaugh. Dr. Ford's testimony was serious and credible. When I asked her directly, "What degree of certainty do you have that Brett Kavanaugh was your attacker?" Dr. Ford answered without hesitation, 100%. I believe her. Judge Kavanaugh's testimony was simply not credible. From his contrived explanations of his embarrassing yearbook entries to his "I love beer" declarations, he was a sharp contrast to Dr. Ford's measured accounting of a horrible day in her life she cannot forget. I had hoped the FBI would be able to provide us with information to resolve unanswered questions, but they can't do their job if their hands are tied. And when the Republicans in the committee and the White House decided to limit the number of witnesses, unfortunately, the investigation could not be completed to meet professional standards. I'll say this to my colleagues. We have to think about what it would mean if Judge Kavanaugh were to be confirmed to the Supreme Court with credible sexual assault allegations against him. Specifically, what it would mean to the millions of women across America who were survivors of sexual assault, women who've been scared to come forward with their stories for fear they'd be mocked, ridiculed, and shunned. What would it mean for them to see Brett Kavanaugh sitting on that bench in that court across the street, day after day, for decades, casting what may be the deciding vote on cases that profoundly affect their rights? It would shake the confidence of millions of Americans in the integrity of our Supreme Court. We should not take that risk. There are other qualified lawyers besides Brett Kavanaugh who could be nominated to fill this vacancy. Nominees whose legal views I may not agree with, but who do not have serious questions about their fitness for office. If there are serious questions about a nominee's temperament, credibility, or judgment, as there clearly are for Judge Brett Kavanaugh, we owe a duty of caution. We should give the benefit of the doubt and protect the integrity of the Supreme Court. With so much at stake, we should not confirm a nominee to the court unless we are sure that the nominee's qualifications are beyond question. I do not have that confidence in Brett Kavanaugh. I will vote no on his nomination.
Mr. President.
The senator from North Carolina.
Thank you, Mr. President. Mr. President, I want to come in and kind of summarize. You and I both, the presiding officer, have had a front row seat in this process. We both serve on the Judiciary Committee, and I think that oftentimes people come to the floor and they want to just give the American public a little slice of what's going on that benefits their narrative rather than stepping back and thinking about what's happened since early July when Judge Kavanaugh was nominated to be on the Supreme Court. That happened on July 9th. Before July 9th, there were many people on the other side of the aisle that had already announced their opposition, not to Judge Kavanaugh, but to anyone that President Trump would nominate. We know who they are. They're very well publicized, and I understand that. As a member of the Democratic Conference, I would deny them their right to do that. They oppose the president and anything that he stands for. But then on July 10th, there was a press conference, now that we knew who the nominee was, that a majority of the members also said they opposed him. As a matter of fact, the minority leader said he would fight the nomination with everything he has, and he has. But there's some pieces to the mechanics that I think are important for people to understand. Briefly after Judge Kavanaugh was nominated, the chair and the ranking member got together and they tried to come up with a framework for releasing as many documents as possible. In fact, that went on for 2 or 3 weeks. In fact, the documents that some of my colleagues on the other side of the aisle said that the Republicans refused to produce were going to be made available on a very focused basis, but with what they call search terms, the way to get into those 100,000 secret documents that they're talking about. We estimate that if our colleagues on the other side of the aisle would have done what they have traditionally done, is come up with agreement on document production, that they would have gained a lot of insights into the documents that we considered relevant, but not necessarily the documents that they would like to use to create another political narrative. But they refused to cooperate, and we moved forward. As a matter of fact, we moved forward and provided more documents for this Supreme Court nominee than the total number of documents provided for all in total of the last 3 or 4 Supreme Court nominees. We also went on to question, or send, they call it questions for the record. What that means is any member on the committee is entitled to compel the nominee to answer questions after the hearing. Judge Kavanaugh was subjected to over 1,200 questions for the record, under oath, that he had to submit back to the committee members. Those questions for the record are a multiple of any one nominee in the past. In fact, I understand it's probably the sum total of questions for the record that all the nominees on the bench were subjected to. So the questions were asked, the documents were presented. All that document production was going on in the latter part of July and August. The first tranche of documents came in about the second week of August. But what else was going on in the latter part of July and August? A letter which was first submitted to a congresswoman from California was then routed to the ranking member and the senior senator from California. In the end of July, a document that was expected to be held in confidence, a document that we now know was authored by Dr. Ford, provided to the Judiciary Committee with the understanding that her name would not become public. Now, in the past, the chair and the ranking member have a great relationship. They have a trusting relationship. In the past, when you had something that you thought was material to the consideration of a nominee, a ranking member and a chair would try to figure out how to actually assess that information to treat the person in question, in this case Dr. Ford, fairly and to hold her information in confidence. That didn't happen here. Actually, there was no communication with the chair by the ranking member. A few weeks into it, we do know that there was some consultation from what Dr. Ford says was a committee staffer to retain an attorney who has a very well-publicized reputation for being partisan. I don't have any problem with that because we've got partisan attorneys on both sides of the aisle. But at the recommendation of a committee staff, which is what Dr. Ford said under oath, they retain an attorney who's working pro bono. Now, I'm really wondering whether or not some, not all, but some of the people on the other side of the aisle genuinely cared about what I believe is a traumatic experience in Dr. Ford's life, genuinely care at trying to go through a process that would provide Dr. Ford with some closure. Because if they had, maybe they would have gotten to someone who could interview her in the way that people experienced with sex crimes interview persons who have experienced a traumatic event. These attorneys who were retained didn't do that. Maybe when the attorneys that she retained, who are pro bono attorneys, that means they're not being paid, they're doing it at no cost, or at least no cost to Dr. Ford. Maybe if the attorneys really cared about Dr. Ford versus the outcome, maybe they should have recommended to Dr. Ford to have the hearing. But that didn't happen either. Now we move further through, and after the hearing, or at the hearing, we have 32 hours of hearings. The letter was known to the ranking member. I don't believe it was known to any other member on the committee. 32 hours of hearings. Each one of us had 2 rounds, virtually an hour to ask questions of Judge Kavanaugh. Not even an abstracted series of questions protecting the identity of Dr. Ford, but questions that could have potentially raised the issues that we now saw after the hearing. 32 hours of hearings, nothing mentioned. An hour and a half private hearing that unfortunately Senator Feinstein, for whatever reason, wasn't able to attend, never brought up. After the hearing, then we hear about these allegations. Now, I've had some people on the other side of the aisle say that we rushed the committee process. The fact of the matter is it was delayed for 2 weeks after we found out about the allegation. 1 week was to get to a point to where we could accommodate Dr. Ford and have her come and testify before the committee. Chair Grassley was criticized by some of the folks on my side of the aisle because he said he shouldn't be accommodating, delaying, set a deadline, move forward. He didn't. He spent the weekend trying to figure out a setting, a method that Dr. Ford would be comfortable with. But let me back up a week earlier. A week earlier, the chairman and the committee offered to Dr. Ford to go to California to interview her outside of the lights, outside of the circus that sometimes occurs here, but to interview her and to have the attorneys present during the interview. In the hearing that we had with Dr. Ford, the question was asked, were you aware that the committee offered to come to California in a confidential setting, allow you to do your testimony? Her response to that question was, I did not understand that. So that really raises a lot of doubts in my mind about either the competence or the agenda of her counsel. So now, at this point, I believe that there are two sets of people who are opposing Judge Kavanaugh's nomination. There are some that just genuinely disagree with his judicial philosophy. I actually have voted for some judges. I disagreed with their judicial philosophy. There are some on the agenda that I will again, but I'm going to vote for them, and I'm going to get criticized from people on the right side of the aisle because they're considered unanimously well qualified. And just because I don't like the way I think they may rule in certain cases, that's not enough for me to vote against them. But maybe for other people on the other side of the aisle there is. Then there's another group of people over there who I genuinely believe have used witnesses, have used this process to just advance a political message and a political agenda. The last thing, another reason why I believe that is how the narrative changes depending upon what sticks. Now, we've received the additional background investigation. I should mention, Judge Kavanaugh's had 7 background investigations over the last 25 years. I saw a stack of documents in a secure facility that's about that thick. I would estimate 600 to 1,000 pages of prior federal FBI background investigations to clear him for other roles that he's had, and 2 in this case. Over 25 years, talking to 150 people, some as recently as about 10 years or less than 10 years after he was in college, not a whiff of any of the allegations that we've seen put forward, not a single note. So, as more information comes up, you see the narrative going from the
1, 2. 1, 2. 1, 2. 1, 2. 1, 2. 1, 2. 1, 2. 1, 2. 1, 2. 1.